segment, we're going to talk about step 1 of the probate process. So step 1 is petitioning the court. And you'll need the following in order to start the probate process. First, you need to petition the probate court. You're going to need a certified death certificate. And you're going to need a valid will if there is one. You need to know for sure that a will does exist or doesn't. And the probate petition is a specific set of probate forms that the court requires. The petition tells the court who passed away, who's applying to be the executor or the administrator, and then who the heirs are, and the assets involved in that probate. Now, a valid will is the most recent will with an original signature. When a person revises their will, the new will automatically cancels any and all previous wills. So the most recent will is the only valid will. Only physical proof of a will is accepted by the probate court. Photocopies may be considered by the court, but they will require extra forms. So what if there isn't a will? Well, the probate process will be a little bit different if there isn't a will. The difference includes questions of who can be the administrator and who will inherit the assets from the estate. And when someone dies without a will, the process is called intestate. And when there isn't a will, which states who is the executor and who are the beneficiaries, the state then rules and determines the sequence of appointing an administrator and who the beneficiaries are. Typically, the surviving spouse is considered, then that is followed by the children of the decedent, and then the parents, and finally the siblings. If there isn't any immediate family, then they go to extended family. And the executor or administrator does not need to know exactly what the deceased owned when filing the petition for probate. At this early stage, and only an estimate of the estate's total value is sufficient. Once the estate is open, then the executor or administrator will have the ability to determine the estate's debts and assets. Now, your next step will be notifying all of the heirs and all of the interested parties. So watch that one next.